Hello and welcome to this training on the sanctions process related to the CARE Act. The topic of today's training is the sanctions process related to the CARE Act, and it provides guidance on managing the CARE Act Accountability Fund per the BIN. And this session is presented by HMA. Let's take a look at the agenda. So today we're going to learn about the sanctions process, as well as when and how funds will be returned to counties. The objectives for today is that you will better understand the CARE Act sanctions process, as well as when and how those funds will be returned. Leading this training today is Amanda Turnin from Health Management Associates. She is a principal with HMA and is working to support TTA endeavors. So I'll turn the time over to Amanda to talk about the sanctions process.
Hi there. We have an important update regarding the CARE Act beginning January 1st, 2026. Changes made by Senate Bill 27 will go into effect. These changes include bipolar 1 disorder with psychotic features will now be included as an eligible diagnosis under the CARE Act, except psychosis related solely to intoxication. This law now defines what it means to be clinically stabilized and ongoing voluntary treatment. Certain court referrals can now serve as a care petition. Criminal courts may consider care referrals earlier for individuals found incompetent to stand trial in misdemeanor cases. Nurse practitioners and physician's assistants are now authorized to complete affidavits in support of care petitions, and there are also some technical amendments to streamline the care process. Our training PDFs, including the notes, have been updated to reflect these changes, including the addition of bipolar 1 disorder with psychotic features, and they are available on the CARE Act Resource Center. But during this training video, you may hear older references to schizophrenia and other psychotic disorders, so keep this update in mind that it will now include bipolar 1 disorder with psychotic features starting January 1st, 2026, and other updates made by Senate Bill 27. Thank you for staying informed, and please review the updated resources linked in your training materials. You can find more information about these changes in our SB 27 brief on the CARE Act Resource Center, or email us at info@careact.org.
Great, thank you. As Patricia mentioned, this training was created in collaboration with the Local Governmental Finance Division. LGFD provides management and oversight of all county and local governmental federal reimbursement and financial oversight activities critical to ensuring access to high quality and cost-efficient healthcare through DHCS's contracted local governmental entities. We will first start off with the CARE Act sanctions process. A brief overview of the CARE Act sanctions overview. Behavioral Health Information Notice 24014 issues guidance to counties regarding the distribution of funds deposited in the CARE Act Accountability Fund. Counties are required to perform specified administrative functions to implement the CARE Act. If the court finds that a county or other local government entity is not complying with court orders, the presiding judge or their designee may issue an order imposing a fine. All funds collected from fines are deposited into the CARE Act Accountability Fund, and all monies in the CARE Act Accountability Fund will be returned to the entity that paid the fine at the end of each fiscal year. These funds are to be used to serve individuals designated by the CARE Act, including individuals who have schizophrenia spectrum or other psychotic disorders, and who are experiencing or at risk of experiencing homelessness, criminal justice involvement, hospitalization, or conservatorship. The process for submitting a CARE Act sanction includes counties paying funds to the State Controller's Office using the County Remittance Advice Form TC31. The State Controller's Office will deposit the funds into the CARE Act Accountability Fund and will communicate receipt of the funds to DHCS. When submitting the form, DHCS requests information and certain documents to be able to return the funds. This includes a written copy of the order imposing the fine or fines, a plan describing how the county intends to use the reimbursed funds to support individuals as described in the previous slide. Information may include, but is not limited to, strategies, programs, and/or services that will be employed to serve the intended population. It should also include county staff contact information, and the documents should be sent to DHCS at the email shown on the slide. The CARE Act sanctions return. So beginning in calendar year 2024, DHCS will annually distribute monies that are in the CARE Act Availability Fund as of June 30th to those counties that paid a fine and met the conditions. DHCS intends to return funds to the county within the first quarter of the following fiscal year. DHCS will notify the counties of the timing and amount of the return funds after the end of the fiscal year by email, and expenditure of these funds is subject to audit. For more information, you can visit TC 31, Frequently Asked Questions.
So again, the learning objectives for today were that you would have an increased ability to understand the CARE Act sanctions process, as well as when and how those funds would be returned to counties. So we have a few additional resources for you. We have the bin listed here with the CARE Act fine and repayment guidance, and also has some frequently asked questions and some defined standards on electronic and digital signatures. Questions can be sent to care_claiming@dhcs.ca.gov, and all the training materials, including the links, can be found on the CARE Act Resource Center, where you access this training. So go ahead and pull that up. All the slides and notes, including the links, can be accessed there. And again, for any residual questions related to this process, please feel free to reach out to care_claiming@dhcs.ca.gov. Thank you.